A single word, like just one word, election, has completely fractured the Supreme Court 5-4. In this landmark Watson v. Republican National Committee decision, the justices are locked in a nationwide legal battle over a seemingly simple question. Does an election end the moment a voter drops their ballot in the mail, or does it end when the state actually opens the envelope? If you enjoy content like this, please take a moment to like, subscribe, follow, and turn on notifications so you'll always know when new content is released. As a quick update, we continue to monitor the Martin Stevens v. OpenAI matter. It is important to note that this is still not a lawsuit. Martin Stevens has suspended his voluntary quiet period after OpenAI filed its confidential S-1 registration statement on June 8, 2026, without first engaging with him, despite having nearly a month since his final notice and more than a year since his initial notifications. Stevens views OpenAI's decision to proceed without any direct interaction as a sign of extreme disrespect. As a result, he has stated that he will not re-enter a quiet period unless it is part of a formal agreement. At the time of this recording, no settlement discussions or negotiations have been publicly confirmed. We can also report that the dead man switch has not been activated, meaning Martin Stevens remains safe from both a physical and legal standpoint. We will provide updates if circumstances change. Welcome to the debate.
Glad to be here, and today we are digging into the Supreme Court's recent slip opinion for Watson v. RNC.
Right, and for those listening who might not follow the courts on a daily basis, a slip opinion is just the expedited initial version of the court's ruling.
Yeah, just the version released before it gets officially published in the bound volumes.
Exactly, but the implications of this particular text are immediate and honestly, they're massive. We're also pulling in analysis today from the Cato Institute and the Voting Rights Lab.
So the core issue here is whether federal election day statutes override state laws, like the one currently operating in Mississippi, right?
Right. Laws that allow mail-in ballots to be received and counted days after Election Day, provided they were postmarked in time. I will be defending Justice Amy Coney Barrett's majority view on this. She basically argues that an election is essentially the voter's act of choosing, which means states retain the discretion to set their own receipt deadlines, and that prevents absolute administrative chaos for midterm elections.
And I will be taking the side of Justice Samuel Alito's dissent. He argues that an election fundamentally requires the authoritative receipt of those ballots. From my perspective, ignoring historical precedent and allowing ballots to arrive days or even weeks late creates severe risks that actively erode public trust in our democratic systems.
Well, let's start with the basic mechanics of what it actually means to vote. Under Barrett's textual interpretation, we have to look at the dictionaries from the 19th century, when these federal statutes were actually written.
Sure.
If you pull up Webster's 1869 dictionary, the definition of election is remarkably straightforward. It is defined as the act of choosing.
Oh, okay, but
hold on. Think about the voter's perspective. When a voter sits at their kitchen table, fills out their ballot, seals it, and hands it to a postal worker by Election Day, their act of choosing is complete. The federal statute sets the time the choice must be made, but it leaves the manner of receiving that choice entirely up to the states.
Right, but you're treating it like a purely private action.
Because it is an action taken by an individual. Think about how we handle other strict federal deadlines. If I mail my tax return to the IRS on April 15th, my legal filing is complete. I have met my obligation, right?
Yes, for a tax return.
It does not matter if the envelope sits in a government sorting facility in Ogden, Utah for 3 weeks before a clerk actually slices it open. The action required by the citizen is finished.
Yeah, the tax return analogy is popular. But I think it entirely misunderstands the mechanics of an election. An election is not an individual administrative transaction between one citizen and the government.
How is it not? You're casting your individual vote.
Because it is a collective, binding decision made by the body politic as a whole. When your single ballot is just sitting in the back of a postal truck, it is legally just an offer to vote.
An offer to vote?
Yes. It doesn't actually become part of the electorate's collective choice until a designated election official takes custody of it. And look, if we're going to trade 19th century dictionaries, look at Bouvier's 1914 Law Dictionary.
Okay.
It explicitly defines an election as casting and receiving. The Montana Supreme Court recognized this exact mechanical reality in the 1944 case, Maddox v. Board of State Canvassers. They ruled that a ballot isn't officially cast until it is received by the board.
Right, but
Federal law demands that the collective choice be finalized on Election Day, and mathematically, that choice isn't finalized until the ballots are gathered in one place.
see, you can't apply that Maddox ruling that broadly because it turned heavily on existing state law in Montana at the time. It wasn't based on some universal federal mandate.
It still addressed the mechanism of voting, though.
It did, but Montana had a specific state statute requiring ballots to be delivered to officials and deposited in a physical box before the polls closed. When they passed a new law allowing soldier ballots to arrive later, they failed to repeal the older delivery requirement. That's why it was struck down.
Even so, the definition of the act requires receipt.
But both the concurring and dissenting justices in that Maddox case went out of their way to note that the state legislature was perfectly free to authorize the counting of late-arriving ballots if they simply amended their own state code properly. There was no absolute federal prohibition stopping them.
Well,
And beyond state-level cases, look at how Congress operates today with the Uniformed and Overseas Citizens Absentee Voting Act, UOCAVA.
right, the Military Voting Act.
Exactly. This is the federal law that guarantees military personnel and overseas citizens the right to vote. UOCAVA explicitly says that a federal absentee ballot shall not be counted if a state receives it after the deadline for receipt of that ballot under state law.
Hold on, let me jump in there.
Let me just finish the thought. If federal law mandated a single uniform national receipt deadline of Election Day, why would Congress deliberately cross-reference state ballot receipt deadlines in UOCAVA?
Because
Oh, they would just say must be received by Election Day. They didn't do that.
they didn't do that because UOCAVA applies to primary elections as well as general elections. The federal Election Day statutes we're debating right now only govern general elections for federal office. They have absolutely no jurisdiction over primaries.
Sure, states control their primaries.
So naturally, UOCVA has to cross-reference state law receipt deadlines because for primaries, state law provides the only deadline. You cannot use that specific cross-reference to prove that states somehow have the power to stretch receipt deadlines for federal general elections past the congressionally mandated Tuesday.
But read the actual text of UOCVA. It doesn't draw that primary versus general distinction anywhere in the phrasing you're referencing. It doesn't say, for primary elections, consult state deadlines.
It's implied by the scope of the law.
It presupposes across the board that the deadline for ballot receipt is a matter of state law. Furthermore, the specific provision in UOCVA directing officials to ensure ballots are received on time applies explicitly to regularly scheduled general elections. Congress was talking about general elections there, and they still deferred to state deadlines.
I hear what you're saying, but even if you read UOCVA that way, we cannot ignore the sheer weight of historical precedent. When Congress enacted the first federal Election Day statutes in 1845, ballot receipt uniformly occurred on Election Day.
Because almost everyone voted in person back then.
And this wasn't just a byproduct of people having to vote in person. Look at the logistics during the Civil War. You had hundreds of thousands of soldiers stationed miles away from their home districts. If federal law allowed these extended grace periods, why did war-torn states construct incredibly burdensome field voting systems?
To ensure soldiers could participate.
But they went to immense trouble. They deputized military officers as election clerks, hauled physical wooden ballot boxes into military camps, and had soldiers vote on the exact Tuesday mandated by Congress.
Wow, hauling wooden boxes to the front lines.
Back to your home county, and we'll count it whenever the Postal Service gets it there. They would have done it. It would have saved immense time and money.
I mean, maybe.
They didn't do it because the legal understanding at the time was that the election had to be completed and the ballots collected on Election Day.
Okay, you are assuming that state legislatures during the Civil War only had one goal, making it as easy as possible for soldiers to vote, and that they went right up to the edge of what federal law allowed.
I think they were trying to be as efficient as the law permitted.
But as Justice Barrett points out in her majority opinion, state legislatures back then utilized Election Day receipt deadlines for reasons that had absolutely nothing to do with federal requirements.
Such as?
For instance, they designed those field voting systems to curb localized fraud. They also strongly believed it was essential to open soldier ballots publicly in the physical presence of the local community to verify their authenticity.
Right.
You can only do that if the ballots arrive by the time in-person voting concludes.
Which perfectly illustrates my point about maintaining trust and verifying authenticity.
But my point is that they did it for local policy reasons, not because a federal statute forced them to. More importantly, 19th century statutes do not lock society in a time capsule.
No, but they established a meaning of the law.
Just because states in the 1860s preferred simultaneous casting and receipt doesn't mean federal law permanently mandated it for all future generations. I mean, by the time we get to World War I, several states, including Maryland and Kansas, had already modernized and implemented post-election grace periods for soldiers overseas. They recognized that relying on the mail required flexibility.
The problem with relying on flexibility is that it ignores the stark realities of modern election mechanics. And this is exactly what Justice Alito zeroed in on. We aren't talking about a few straggling ballots coming in from a trench in France anymore.
No, obviously the scale is different.
Look at the mechanics of what happens today. In Mississippi, the law allows ballots to arrive up to 5 days later. In Washington state, they accept ballots up to 21 days after Election Day.
Right, 3 weeks.
You structurally invite suspicion.
But early results are precisely that. They're preliminary. Every news network flashes a graphic saying projected. The media calling a race doesn't mean the legal mechanics of the election are over.
It's not about the media, though. It's about how the vulnerability works. If you're listening and wondering why late arriving ballots are such a flashpoint for fraud, look at the historical precedent of the 1948 Lyndon Johnson Senate runoff in Texas.
The infamous Box 13?
Exactly. It perfectly illustrates the mechanical danger. On election night, the polls close, the preliminary counts go up, and LBJ is trailing his opponent by a specific margin.
Right.
6 days later, 202 late-arriving votes miraculously materialize in Precinct 13 in Jim Wells County.
Oh, wow.
And shocker, they break 200-2 in LBJ's favor, allowing him to win the statewide race by exactly 87 votes.
Yeah, it's a crazy piece of history.
When you leave the counting window open, you show bad actors exactly how many votes they need to fabricate to flip a race. Whether it's 1948 or 2026, when a candidate is leading on Tuesday night and then tranches of mail-in ballots slowly erode and flip that lead over the next 2 weeks, it deeply damages public faith in the electoral process.
I see the concern.
Without a strict, legally binding receipt deadline, the concept of a single election day is meaningless. It just becomes the opening day of a month-long counting season.
Look, I entirely acknowledge the gravity of voter trust. If the public doesn't believe the results are accurate, the system fails. But I would point you to the argument raised by Walter Olson at the Cato Institute, which focuses on the proper role of the courts.
Okay, what does he argue?
Policy concerns about election integrity, fraud vulnerabilities, and voter confidence belong to the legislature. They do not belong to the judiciary. If you're listening right now and wondering why someone doesn't just fix this timeline, the answer is that Congress has the explicit constitutional authority under the Elections Clause to pass a law tomorrow mandating that all ballots be in the physical hands of election officials by 8 p.m. on Election Day.
They could, yes.
They could create a uniform national receipt deadline, but they haven't. And the Supreme Court's job is not to stretch the definition of a vague 1845 statute to solve a 2026 policy grievance.
The court's job is to enforce the word election as it was understood when Congress passed the law in 1845. And as Bouvier's dictionary and the Civil War practices establish, it was understood to include the receipt of the ballot.
But let's look at the immediate, tangible consequences if the court had actually sided with your historical interpretation. We are sitting just months away from the 2026 midterms.
Right.
If the Supreme Court had suddenly struck down these grace periods, they would have instantly invalidated the election laws in over a dozen states.
It would have been disruptive, I won't deny that.
According to the Voting Rights Lab, this would have caused absolute administrative chaos. Take Mississippi. The state legislature there has legally banned drop boxes. Voters can only return ballots by mail or in person.
Yeah.
and your ballot gets delayed at a sorting facility through no fault of your own. Striking down this grace period means your legally cast vote is thrown in the trash. It would acutely disenfranchise military voters overseas who mathematically require that transit time to participate.
That is unfortunate, but
The very chaos and distrust you are trying to prevent would be triggered immediately by judicially nullifying the rules right before people vote.
that is an administrative concern, not a legal one. I don't deny that transitioning back to a strict Election Day receipt deadline would require logistical adjustments. States might have to mail their absentee ballots out earlier, or voters might have to put them in the mailbox a week sooner.
Which isn't always possible for military personnel.
True, but administrative convenience cannot override the actual text of the statute. And bringing up the Postal Service actually highlights a massive mechanical flaw in Mississippi's system.
What flaw?
The Postal Service, along with common carriers like FedEx, legally allows customers to recall mail mid-transit.
Okay, where are you going with this?
Think about it. If a Mississippi voter can put a ballot in the mail on Monday, regret their choice on Tuesday morning, go down to the post office and intercept that piece of mail before it reaches the county clerk on Friday, then how can we possibly argue their choice was finalized on Election Day?
That is highly theoretical.
The electorate's choice is not truly made until the ballot is irrevocably out of the voter's control and in the hands of the state.
The postal recall scenario is a fascinating edge case, I'll admit. But as Justice Barrett noted, the plaintiffs didn't even bring up that argument until their reply briefs in the appellate court. It wasn't the substantive basis of the litigation.
It still illustrates the mechanical reality of the mail system.
And even if Mississippi law technically allowed for a ballot to be intercepted mid-transit, which the state vehemently denies happens in practice, the core legal question is whether post-election day receipt conflicts with federal law. It doesn't. A voter's act of choosing is complete when they cast the ballot. The fact that the state's logistical infrastructure takes 5 days to process the mail delivery doesn't retroactively alter the moment the voter made their choice.
I simply cannot reconcile the constitutional idea of an election day with a mechanical system where the determining votes are physically sitting in a postal sorting facility days after the polls have closed.
Why not? The Constitution deals with transmission delays all the time.
Because when the Constitution discusses the Electoral College, it mandates a specific uniform day that electors must give their votes. It demands uniformity to prevent manipulation. To argue that Congress wanted a uniform day for casting votes, but was completely indifferent to when those votes were actually collected and tallied, defies the entire logical purpose of having a federal election day in the first place. But the whole reason Congress passed the original Election Day statute in 1845 was to stop the fraud of states holding elections on different days, which allowed bad actors to literally move voters across state lines. Allowing rolling receipt deadlines resurrects the exact problem of localized manipulation the statute was designed to solve.
But you are conflating the act of voting with the administrative timeline of counting, and we need to clarify how different these mechanisms are. You mentioned the Electoral College.
Right.
The Constitution requires electors to vote on the same day, yes, but it explicitly says they must then transmit their votes to the seat of the government. 18th century transmission was done by a guy on a horse. There was no same-day delivery.
Ha, true.
The founders deliberately built a system where the time of voting was uniform, but the receipt happened down the line. The federal Election Day statutes follow that exact same constitutional logic. They set the deadline for when the people must vote, but they leave the logistics of receipt to the states.
If we are going to explain it like that, we have to acknowledge this staggering difference in scale. Transmitting an Electoral College certificate in 1789 meant moving a few dozen pieces of paper securely across the country.
Right.
That is fundamentally different from a mass public election today, where 150 million individual mail-in envelopes are filtering in from thousands of various sources, sitting in unsecured mailrooms, vulnerable to interception, harvesting, or localized delay. The scale of the mechanics and the sheer surface area for vulnerability are entirely different. You cannot compare 50 electors to 150 million mail-in ballots.
The scale is absolutely different, but the legal mechanism of deferring receipt is exactly the same.
Adhering strictly to the text of the statutes preserves federalism. It protects military and rural voters who are structurally reliant on the Postal Service, and it correctly leaves the complex mechanics of election administration to state legislators, not federal judges.
So you're saying it's just not the court's problem?
I'm saying if the word election simply means the act of choosing, that a ballot postmarked by Election Day fulfills the federal requirement. It is not the judiciary's place to insert a hard receipt deadline that Congress never bothered to write.
And my perspective remains that without a firm receipt deadline, the concept of a single election day is rendered practically meaningless. An election, by its very nature, requires the authoritative collection of the ballots to be legally conclusive. By allowing millions of ballots to trickle in days or weeks after the preliminary margins are known, we are ignoring the historical context of how these statutes were built to prevent fraud. More dangerously, we are ignoring the mechanics of human behavior, risking severe damage to the perceived integrity of the electoral process.
I think where we can certainly find a point of convergence here is that the ambiguity of these 19th century statutes creates incredibly messy realities for modern election administrators. I mean, the logistics of how people voted in 1845 simply do not map cleanly onto how they vote in 2026.
Absolutely. And I think we both share a deep concern for maintaining public trust in our democratic institutions. If the public doesn't believe the system works, the text of the law hardly matters. Where we respectfully continue to disagree is whether the courts have a duty to interpret the law to fix this timeline, or if we just have to wait on a gridlocked legislature.
Exactly. It's a fascinating reflection on the tension between textualism, historical precedent, and pragmatic policy concerns. I highly suggest that our listeners explore the varying state laws detailed in the Voting Rights Lab report.
Yeah, it's very comprehensive.
And read the full slip opinion from the Supreme Court to truly understand this intricate balance of federalism and election integrity.
Because the law, much like the elections it governs, is rarely as clean as we want it to be. The question of when exactly a choice becomes final is one we'll likely be debating for a long time.
If you found this episode valuable, please like, subscribe, share, follow, and turn on notifications. It helps us continue bringing you content like this and ensures you never miss future releases.